Good afternoon to those of you here in D.C., and good afternoon and good morning to those of you listening in across the country. Welcome to our program today entitled You're Not Covered for Everything, Making Sure Your Nonprofits, Directors, and Officers' Insurance Coverage Matches Your Expectations. Today's program is being recorded, by the way. As many of you know, this is part of our monthly series on nonprofit legal topics that we do here at Venable in our D.C. office every month, and pipe across the web for those of you across the country who would like to participate. And thankfully, many of you do. We have a good crowd here, about 75 folks in D.C. today and over 200 folks on the telephone across the country. So we're glad to see the interest in today's topic. My name is Jeff Tenenbaum. I'm the chair of the nonprofit organizations practice here at the Venable Law Firm. It's very gratifying as well to see many of you here in person, and I saw the list on the telephone. We have a lot of repeat attendees, which hopefully means we're doing a good job in conveying some valuable information. Today's program, I'm sure, is going to be no exception. Insurance, maybe not one of the sexiest topics that you've ever dealt with or that we've ever dealt with, but to me, one of the more interesting and important topics as a nonprofit attorney. It's an area that I've always had a personal interest in and spent a lot of time learning about and counseling clients about over the years. Thankfully for me, though, I have one of our speakers here today, my colleague D.S. Gray, who, when I discovered his expertise a number of years ago here at the firm in terms of insurance coverage analysis and expertise, and really DS has developed a real emphasis and focus on nonprofit organizations and nonprofit insurance coverage. It's made my life a hell of a lot easier, and DS has worked with many, probably hundreds of our nonprofit clients over the years in doing insurance coverage reviews, and of course is focused on directors and officers liability insurance as well as other types of insurance, and really from those experiences has a lot of great information and wisdom to impart to you here today. To DS's right is Lou Novick. Lou is the president of the Novick Group. For those of you in the nonprofit community in the D.C. area in particular, Lou is very well known. Lou's been a friend for many years. We've worked with many common clients and known each other from the association and nonprofit worlds here in D.C. First-rate professional, knows his stuff in this area inside and out, has some great experiences and insights that will kind of be imparted on you today, and we're grateful and thankful for Lou joining us for today's program. You can find full bios for DS and Lou in your handout materials. A few logistics before we get started. As always, questions. We encourage you to ask questions throughout the program. For those of you in the room, just raise your hands, and I'll call on you at the appropriate times, and our speakers will repeat the questions for the benefit of those of you on the telephone before they give answers. For those of you on the phone, you need to pose your questions using the chat feature on the webinar software. I will be manning the laptop at the front of the room, and we'll pose those questions to our speakers at the appropriate times, or sometimes just answer you directly myself. Handout materials. Those of you here in the room have a printed copy of the PowerPoint slides as well as an article that DS recently authored on nonprofit insurance coverage issues that I would definitely commend you to take a look at. Those of you on the telephone should have gotten a copy of the PowerPoint slides emailed out to you, and a confirmation email, I believe, yesterday. Tomorrow, all of you will receive an email that contains a link to a recording of today's program, along with the synced PowerPoint slides and that article I mentioned in the bios of the speakers. Feel free to forward that recording link to others in your organization or elsewhere who you think may benefit from it. As many of you know, all of the recordings of our monthly legal seminars that we've been doing now for the last year and a half or so are posted on our firm's website at venable.com/nonprofit/recordings. That link can be found on the last slide of today's PowerPoint. I should also note that just this morning I saw that a webinar that we did last week for GuideStar that was very well received on nonprofit executive compensation was posted on their website. They sent us a link to that recording. We thus have posted that link on that same place I just mentioned to you. So if you're interested in nonprofit executive compensation and all of the legal and particularly IRS issues that go along with that, my colleague Matt Drenny and I did a webinar for GuideStar last week and another one in June. Both of those are listed there. It's a very hot topic right now. You might want to take a look at that. Promotion for upcoming programs. What you're looking at here on the screen has actually just been modified as of this morning. We try, as you know, in these programs to be flexible enough to be able to address hot topics as they arise. Some of the topics we cover are very kind of new development, hot topic issues, and some are equally, if not more important, but issues that never go away but are always equally important. We really have a mix here coming up. On November 13th, that program is the same, Office Leasing for Nonprofits, Mastering the Key Issues. We have two of my really talented colleagues, one from D.C. and one from New York, who are going to be speaking at that program. On December 11th, it's not going to be the program that's up there on the slide. The program on December 11th is going to be entitled Exchanges Under Healthcare Reform and Private Exchanges, What Does My Nonprofit Need to Know? A colleague of mine, Chris Condalucci, who worked on the Senate Finance Committee staff when the healthcare reform legislation was drafted and has become a real expert not only in healthcare reform but in these exchanges, specifically, along with another outside speaker, are going to be speaking on that topic on December 11th. As many of you know, it's a very hot topic, and even more so of a hot topic here in D.C. because of a proposed mandate that D.C. is moving forward with. That's a program you may not want to miss. And then finally, on January 8th, the program that's up there on the slide, Exempt or Non-Exempt, the 10 Most Common Employee Classification Pitfalls Faced by Nonprofits, will be held on January 8th with two of my talented employment law colleagues, one from New York and one from Los Angeles. Finally, I want to thank Pat Reed, who has more than ably been filling in for Jamie Fitzsimons, who's out on maternity leave. Pat's been doing a great job helping us out. And with that, I'm going to turn it over to DS to get us started.
Good afternoon. Good morning to those on the phone. My name is D.S. Ray. Thanks, Jeff, so much for the very warm welcome. Today we're going to talk a little bit about practical issues associated with the purchase, selection, and use of D&O insurance by nonprofit organizations. Jeff has already given my disclaimer, which is this perhaps may strike some as not the most interesting or important topic, but I submit to you that if you've ever received a complaint in the mail or from a process server, in your capacity as a director or officer, your insurance policy at that point becomes mighty important. So let's do what we can to improve the coverage that you've obtained, as well as identify some pitfalls that you need to avoid in obtaining future policies. So let's begin with a very simple, basic question that every officer, director, or executive needs to ask him or herself before agreeing to work for a nonprofit organization, and that is, how likely are you to be sued in your personal capacity and for an act or an alleged failure to act as a director or officer of your nonprofit organization? Earlier this year, Chubb released the results of a public company risk survey in which it asked public company executives that question. The survey says more than 80% of those surveyed from 145 public companies in the United States and Canada considered it to be not likely. Chubb's response? Very disconcerting. One of the reasons it was disconcerting is because nearly one quarter, those math majors out there may say 75%, were able to avoid this, but one quarter of the directors or officers of the responding company already had been sued. In other words, their names were among the defendants listed below the V on the caption in the complaint. Without D&O coverage, the dollars required to defend and or settle those lawsuits could come from that director's or that officer's very own pocketbook. At Venable, we haven't seen any sign of this slowing down. 2011 was a record year for settlements of claims filed under the Foreign Corrupt Practices Act, which basically prohibits certain payments to foreign officials and companies for the purposes of obtaining business. The July-August 2012 issue of the Metropolitan Corporate Council reported that in the last decade, there has been, quote, increased liability exposure for directors and officers due in large part to financial scandals, accounting restatement cases, and the resulting increased regulation, close quote, imposed by Sarbanes-Oxley and Dodd-Frank. Even selling the importance of D&O insurance inside nonprofit organizations has become more difficult. Generally addressing the issue of insurance, Leslie White from Croydon Consulting, hopefully I got that name right, posted the following as part of the Risky Chronicles blog back in May. Associations and nonprofits should expect their annual premiums to increase for the next few years. But nonprofit organizations are still recovering from the Great Recession and money is tight. Many have already reduced their insurance costs by lowering policy limits, increasing deductibles, and or eliminating coverages. How much lower can they go? From an insurance coverage attorney's standpoint, the answer to that question is neither simple nor settling. So why should you care? Granted, the data that Chubb reported involved public companies, and granted, those sorts of directors and officers face different liabilities than those who work for nonprofit organizations. For one thing, you, and I mean the specific you, not your organization you, may be a defendant. Choosing between a director and an officer in an organization is not an option for plaintiffs. Many plaintiffs choose to sue both. Why? You may be another pocket. You may be another source of exercising leverage to secure that settlement or that judgment. That brings us to our third point, strategic advantages. What better way to force a nonprofit organization to settle a claim than to file the claim directly against its president and threaten every dollar she has worked so hard to save? What happens if the organization's president lives in a so-called judicial hellhole? That is, a jurisdiction that plaintiffs' attorneys like to file suits in because they think they get better judges and better juries. Let's assume that you're right, that you're not going to be liable or that you're judgment-proof. Who's going to pay for the attorneys? Is that coming out of your pocket or from a D&O insurer? To be sure, covering judgments and settlements is one value that D&O insurance provides, but it's not the only one. Sometimes paying the attorneys may be even more valuable. So you should care because your D&O policy can literally be the foundation on which your organization stands. It's there to protect your most valuable asset, that is your people, from very real and very personal liabilities. Now, I'm very cognizant of the very limited time that you have today. I'm appreciative of everyone coming out and being on the phone, but I'm also very cognizant of the limited time that you have to deal with insurance coverage issues. I'm therefore going to focus on very small, very, very functional steps that you can take to ensure that your nonprofit organization gets the most out of its D&O policy. Now, previously, whenever I've talked to clients about this, I've been told that this is common sense. Every bit of the common sense that you hear today, was learned the very hard way by very sophisticated nonprofit organizations. Jeff, myself, others in Venable's nonprofit practice group have had to work with these clients to either right the ship or explain to them why the insurance company has properly denied their claim. And all of these issues could have been very easily prevented with a little due diligence and persistence. So what are we going to talk about? First, we're going to talk about how D&O insurance fits into your overall insurance plan, your insurance program, your risk management program. Second, we're going to talk about how you can match your potential risks with your D&O coverage. Third, we're going to talk about who does the matching with you, and believe me, you have to be part of the process. Step 4, we're going to identify potential gaps in D&O coverage. Again, some of this is war stories over the years of things that Jeff and I have seen helping nonprofit organizations. And fifth, we're going to talk about ways you can satisfy your obligations to make sure that the D&O coverage that you've purchased is there when you need it most.
Diaz, can I interrupt you for a second?
Absolutely.
Just want to make sure everyone understands before we launch into a lot of the details that even the name Directors and Officers Liability Insurance can be a bit of a misnomer. And as Diaz has already alluded to, and as Diaz and Lou are going to get into in a lot more detail, this type of insurance covers much more than just directors and officers. We're going to talk very specifically about other individuals whom it generally covers, such as employees and committee members, et cetera, and volunteers. But very importantly, and don't forget this, it also covers the entity itself. And while there are many reasons why these individuals are often named as defendants or co-defendants in lawsuits and other actions, it's the entity itself that's often the biggest target because it generally has the deepest pockets. So always keep that in mind, the types of claims, we're talking about the types of different lawsuits that can be brought and whatnot, and what types of claims D&O covers and doesn't. While it's all very important with respect to the individuals, in my experience, it's equally, if not more important, to recognize the coverage it provides for the entity itself.
Believe it or not, Jeff and I did not work that out beforehand. Let's talk about what a D&O policy is. But first, let's be very, very hyper-technical for a few moments. Just as Jeff explained, it's called Directors and Officers Insurance. When it was originally created, it was intended to protect directors and officers of for-profit entities. Over time, however, it has evolved so that it has been brought into the nonprofit world. Some of you may have purchased or may be looking at so-called nonprofit organization policies or association professional liability policies that refer to the type of coverage as D&O. That's what we're going to talk about today. Now, the purpose of D&O policies is to protect directors, officers, and other representatives of insured organizations against certain third-party losses arising from wrongful acts in their official capacities. So let's break that down. First, insured organizations. That's you. That's the name of your organization. It sounds easy, but believe it or not, there are some fundamental things that need to be done to make sure that your organization is, in fact, the insured under the policy. Then we refer to third-party losses. That means someone outside of your organization, someone who's not a director, not an officer, not an employee, has suffered the loss and is making a claim or filing suit against your organization. There are some exceptions to that, but that's generally what we're talking about. First-party policies are things like property insurance. That is, you own an office space, you have a flood, you need coverage, and you get the money from the insurance company or the folks who happen to repair your office space. It's paid directly on behalf of the insured, to the insured. Then we have arising from wrongful acts. Now, wrongful acts can be pretty much anything that you can imagine, but typically it involves actions or failures to act in a management capacity or in some sort of action on behalf of the organization. These wrongful acts have to occur in the course of the work performed for the nonprofit organization. So the better you describe the work that you do as part of the application process, the better your insurer can understand the work that you do, can better price the policy, and can better assure you coverage when things go awry.
Yes, let me just note for a second that this is one area where one thing we should note about D&O policies, perhaps more, and our experts here can speak to this better than I can, but perhaps more than most other types of policies that nonprofits deal with, there is no standard form. There is no one-size-fits-all. I have seen so many different nonprofit D&O policies over the years, and sometimes they vary wildly, and perhaps more so than in any other area in the definition of a wrongful act and or the exclusions from what is covered by that definition of a wrongful act. There are lots of other differences between nonprofit D&O policies, but this is something you're really going to want to zero in on. And like DS said, fully describing to a talented nonprofit insurance broker like Lou what your organization does, what its primary activities are, what its primary risks are, is going to enable him to go out there and find the policy that's best suited for your risks. So you don't want to just go and purchase the policy that your neighboring nonprofit down the street said, oh, we have this great policy, it's a great price. We worked with Lou too, and he got us a great deal on the premiums, that you should get it too. Your organization may have very different risks, and you may need a very different definition of wrongful acts in order to be sure that you're covered for your primary risks.
Excellent.
I would add something, but you guys just haven't left anything on the table for me. Thank you.
Especially the part where we said, go to Lou.
What did you say?
Especially for the part where we said, go to Lou. Okay, so the wrongful acts, again, kind of like the precursor, kind of like the underlying theme to all of this, is read the policy, understand the policy, talk to folks like Lou or your insurance coverage counsel, and ask them, what does this mean if you don't understand it, or if you need to, again, go to those very organization-specific definitions to make sure that you're covered. So let's go back again talking generally about D&O insurance. Generally speaking, there are three sides, A, B, and C. A typically covers that which is paid directly on behalf of the director or officer pursuant to the bylaws and other corporate governing issues. B is that which is paid by the organization on behalf of those individuals and reimbursed to them. And C is typically, it was originally created for securities-like purposes, for security risks, to cover organizations. In the nonprofit world, however, we've seen coverage C expand considerably simply because the types of expectations and the coverages needed are so very different. So at least from my experience, coverage C has grown considerably over time. That's exactly the point that Jeff was making, and that D&O has evolved into one vehicle by which nonprofit organizations themselves can protect themselves against lawsuits and the like. Policy periods are very, very important. They determine and they identify the length of time for which you're covered. They're typically set in years. For example, October 16, 2012 to October 16, 2013. This is incredibly important for D&O policies because these are claims-made policies. Generally speaking, D&O policies focus in on when you receive notice of a claim or a potential claim. So even if something happened in 2010 that gave rise to a claim or a lawsuit filed against you tomorrow, it's going to be your D&O policy in effect tomorrow. That's the one that's going to provide you with the coverage. That's the insurer to whom you need to submit the claim. The flip side, and trust me, there are gradients here. The flip side is our occurrence policies. Those are like your CGL, your commercial general liability policies. Those are more occurrence-based. So again, going back to our hypothetical, something that happens in 2010, you get sued tomorrow. The CGL policy in place, if that's the policy that's been triggered, it's going to be the one that was in place in 2010. That's the insurer to whom you need to submit a claim. All right. So let's put D&O insurance in its place. In our experience, nonprofit organizations get into trouble when they purchase their D&O coverage and then they try to push the boundaries. So I'm going to generally talk about general types of insurance that are available. To the extent that you decide not to purchase these policies, don't necessarily expect your D&O coverage to kind of fill the gap if you find yourself sued. The first example I've got up here is errors and omissions insurance. This type of insurance basically covers acts of negligence that occur during the work that you do on behalf of your nonprofit organization, and generally focuses on acts of employees, not necessarily directors, not necessarily officers, and not necessarily wrongful acts. We're looking at negligence here. Now, if you're looking to purchase an insurance policy that's going to guarantee your work such that you're never going to be found liable for breach of contract, I'd like to hear about that insurance policy because it's going to be a tough one to find. Generally speaking, insurance policies don't protect you against breach of contract claims. It's when you have negligence or some sort of problems. You know, a guy like me, insurance coverage guy, he's concerned about his malpractice insurance. It's kind of like malpractice insurance for the nonprofit that can be translated into the nonprofit world. These types of policies can be standalone, or you can latch them on to a D&O policy, for example. One example that I've seen is I saw a nonprofit organization that actually had a standalone errors and omissions policy to cover its legal department. That's because that nonprofit's legal department did things and provided counsel that had nothing to do with the actual business of the nonprofit. So I thought that was a very good idea.
Yeah, and just to tag on to something you just said, DS's point about being careful not to try to push the envelope of your D&O insurance too far is a very good point. And what he really means by that is if you try to expand it so much to try to cover all of the risks that you think would fall into the bucket of that policy, you may find yourself without coverage where you've pushed that envelope too far and the insurance carrier decides to push back. As we'll get into later, it's sometimes because not everything is black and white in terms of what's covered and who's covered and under what circumstances. We've seen over the years, and this is when DS and I work together a lot, is when there is a lot of gray area and the insurance carrier is pushing back on coverage, and we have to push back on behalf of the nonprofit organization. But one way to help ensure that you don't get into those situations as much is if you have unusual activities or different risks that aren't typically covered by a D&O policy, instead of trying to fit that square peg into a round hole, go out and find an errors and omissions policy that really does specifically address and clearly covers your risks. That may be the better way to do it. It may or may not be the most cost-efficient way to do it, and certainly you'd be talking about 2 policies instead of 1. But in the end, what you're looking for is to make sure that you have coverage when the need arises.
Yes, sir.
One question. Most community nonprofits use volunteers or people come enter into pro bono arrangements. Now, if those people wind up, say, working in a particular community and then are at risk, something happens to them, can they or their families bring suit against the nonprofit because the nonprofit protects the backbone, pro bono or volunteer opportunity? And is an error and admissions assurance designed, many of them, to guard against that or to help you, to assure you against that?
I'm going to
When you generalize the question.
Yeah, I'm going to do my best to generalize the question, and that is, we're talking about community nonprofits, and we're relying on volunteers. And can the community nonprofits be liable for suits from volunteers who are injured as part of the activities on behalf of the community nonprofit? Did I summarize?
That's clear, yes.
Okay.
Does the community nonprofit put them in harm's way, basically?
Right. So you have a volunteer volunteering on behalf of a nonprofit. Perhaps the activity has some physical risk attached to it, helping to build a home for Habitat for Humanity, things like that. The volunteer gets injured, claims that the nonprofit was negligent in how they set up or oversaw or policed the work site or whatnot, and therefore the nonprofit was negligent in causing the injury and they should be liable. The volunteer files suit against the organization. I think your question is what type of policy would the nonprofit want to cover that sort of claim?
And the answer is it varies. It's available. I've seen it used as part of an employment practices policy. I've even seen a workers' compensation policy that was directly extended to volunteers. I can see that being covered by commercial general liability policy, depending on where it happened, when it happened, whether it was subject to exclusions and that sort of thing. Lou, do you have any other?
Well, I can tell you where it wouldn't be covered, and that wouldn't be covered under the directors and officers liability, because one of the foundation principles of directors and officers liability is there's no coverage for bodily injury or property damage. So that right there is going to defeat the bodily injury claim that's brought by the injured volunteer's family. As Diaz said, there's a number of ways to approach it. You can include volunteers as additionally insured on a worker compensation policy. It's a pretty pricey way to do business because you end up having to impute the value of the volunteer labor and you pay a premium for that. I think most organizations would find it more cost-effective to handle the exposure to liability from volunteer activities where they're injured with an accident insurance policy, what many of you probably call a travel accident or something like that. Fairly inexpensive. It's effectively an accidental death and dismemberment type of a policy, and that's probably the most cost-effective way to deal with that. The liability claim is something different. If they're going to sue the insured, if they're going to sue the association, that's not going to be covered under an accident insurance policy. And it may be excluded under a general liability policy as well.
Just to tag on one other example that I've actually seen cover that sort of scenario, and I agree with everything Lou said. I've also seen special events policies be issued that would cover that sort of scenario, depending on if it happened at the yearly convention that everyone knew about, and that you took out a policy to basically cover lots of different liabilities arising from that special event. That's one other way you could cover it, again, depending on the circumstances of the injury. All right? We'll go back to the slide. Automobile insurance. If your nonprofit has an automobile or two, it better have automobile insurance. It's required by state law. If it doesn't, you still should think about it, because generally speaking, the policies that are purchased by nonprofit organizations generally provide better coverage, generally provide more efficient coverage and better pricing, and you're also not dealing with folks making decisions at a rental car desk. So generally speaking, you get a better product that way. I alluded to previously the commercial general liability policy. This is known colloquially as the CGL. It's something of a blanket policy to cover the personal injuries, like the gentleman previously alluded to. Those sorts of things generally, these policies generally cover incidents and accidents that happen as part of everyday life. It's a little bit like your homeowner's insurance or your renter's insurance if somebody comes onto your property and slips on your wet floor or something like that. Today's CGLs, however, have many more exclusions than they did when they were originally created. ERISA and fiduciary insurance, if your nonprofit organization or related entity engages in any or has any retirement plan, profit sharing plan, insurance plan, these sorts of policies are absolutely required, if not legally required. We finally go on to employee dishonesty fidelity insurance. As its name implies, this is basically to protect your organization against employee theft. These can be third-party claims. These can be first-party claims to actually protect the organization against its own employees. But if you're thinking that your organization can tolerate ongoing malfeasance, this insurance policy is not going to tolerate that either. Property damage insurance. If you have physical structures, you can actually insure also employee property with this first-party policy. Umbrella insurance or excess insurance, very flexible type of insurance that can basically fit on lots of different types of policies once you get through the primary policy. So, for example, you can have an umbrella insurance or an excess insurance policy put right on top of your D&O policy. So if you burn through that first $1 million, you can get into the excess level. Typically, you have more exclusions, you have more conditions, it's a little bit more restrained. Finally, we get to workers' compensation insurance, which is absolutely required under state law, and it's also critical to maintain your immunity or your workers' compensation defense, thereby forcing all of your employees to go through workers' compensation as opposed to filing suits against you. Believe it or not, this policy does have some interface with, or some interaction rather, with your D&O, insofar as your D&O may have employment practices liability insurance kind of glommed on top of it, and you're going to want to be sure to coordinate those coverages to make sure that there are no overlaps or gaps. And finally, we come to the specialty policies. I kind of think of insurance as a little bit like ice cream, insofar as back in the 80s it was Baskin-Robbins, you had your 32 flavors, whereas now you can have specialty policies that can cover a whole host of different risks. You can have things that cover risks from the internet, privacy, kidnapping. I mean, if you can imagine it, there's probably a policy out there that you can buy to insure against the risk. But as Lou and I were discussing earlier today, there are certain risks that you're just not going to be able to insure against no matter what kind of specialty policy you get. The one that Lou mentioned, which was the holy shikes moment, which is if you're an educational institution and you are sued for child molestation or something that happened by one of your principals, one of your teachers, D&O insurance, CGL insurance, you're not going to find any insurance that's going to provide coverage to that individual simply because of the nature of the acts. So, and in some states, you can buy insurance against punitive damages all you want, but by law, some states refuse to allow insurance companies to pay for punitive damages. So specialty policies, you can look for them, but they're not necessarily there for every risk you may want to try to insure. I've seen blanket policies, all risks policies, and then the nonprofit organization policies. My point here is that one size does not fit all. So this doesn't mean that every insurance policy needs to be custom fitted to your exact specifications. It means that you need to keep your organization in mind when you're choosing whether or not to purchase a D&O policy. Can these nonprofit organization policies provide adequate D&O coverage? Absolutely. If your organization happens to be the one the insurer had in mind when it wrote the policy, or you make sure the specific terms of the policy match well with your expectations and your activities of your organization. Let me try and explain it to you this way. If everyone in the room and everyone on the phone got the nonprofit organization policy, is it really realistic to expect that that's going to provide optimal coverage for those of you who operate on an international or national scale, as well as those who work on a regional or local scale, as well as those who are trade organizations or trade associations, as well as those that run educational institutions, as well as those who work with the young, as well as ones who work with the old? Obviously, the diversity of your organizations requires you to take a close look at these types of policies to make sure the match is there. So matching your organization's potential risks to its D&O coverage begins with the foundation. That is, making sure that you are identified as the insured. Again, sounds very simple, very straightforward, but it can be incredibly difficult to submit a claim to an insurance company that has one name on the name insured box and one name on the complaint. So be very particular when you're applying for your D&O coverage. Get your name right in the application, in the policy, in the renewals. If you change your name, be sure to let your insurance company know. Just because the insurance company, again, the red flags will go up if the name on the policy is different from the name on the complaint. I would encourage nonprofit organizations to make sure you include your street name, anything that you can imagine being below that V on the caption of the complaint that's filed against your organization.
In many organizations, it's not uncommon to have their legal corporate name that's on file with, say, the Secretary of State's office or the D.C. Department of Consumer and Regulatory Affairs. Your official corporate name that's on file may be different from the name that you commonly utilize, but when someone's going to file a lawsuit, they're going to pull up your corporate records and they're going to file suit against the corporate name. But if you submitted the insurance application with the DBA name or the commonly used name that you go by as opposed to your full corporate name, you may find yourself having an issue. Similarly, and Diaz is going to talk about subsidiaries and affiliates next, I believe. But even within an organization that has a single legal entity but has, for instance, divisions or chapters, which are all part of the same corporation, but they go by their own names that refer to their state or their city or their region or whatnot, someone could file a lawsuit against that particular region and not recognizing that it's part of your legal entity. As long as you can demonstrate that that region is part of your corporate entity and the name on your insurance application matches up to your legal corporate name, you should be okay in that situation. But pay very close attention to that. We have definitely seen issues and problems in that area.
Let me just add a thought about who should appear as a named insured on a director's and officer's liability policy. Very often we'll see organizations that include the such and such committee or the such and such special interest group. And we generally question whether the value of elevating basically an administrative construction within the organization to the level of genuine named insured. To add the such and such interest group of the organization, in my view, it's the equivalent of saying, well, I'm going to add the membership department, or I'm going to add legal affairs as a named insured. The operations of the interest group or the section, whatever it may be, so long as they're not independent of the organization, they're embedded in you. And the caution that I would leave you with about adding entities like that or departments or units or SIGs or whatever you want to call them is that if you're not exhaustive in doing that, if you add this SIG but not that SIG, are you creating some sort of a precedent when the insurance company will come back and say, well, look, you added the international section, but you didn't add the government affairs section. Obviously, you didn't intend for coverage for them.
And I think that Lou raises a great point. It goes right into my next point, which is don't assume that your insurers know who you are. We've talked a little bit about subsidiaries, parents, affiliated organizations, member organizations, committees, branches. Again, there are no hard and fast rules here. Unfortunately, we gave out all the silver bullets during yesterday's presentation. So we're going to have to go with general guidance here. If your subsidiary organization is the entity by which your organization does its work, it's going to be covered. But if it's financing itself, if it's touting itself, if it's holding itself out separately from your organization, if it's got its own membership, if it doesn't report to you, if it just kind of advises you as to what it's doing, the insurance company may glom onto something like that. So you just need to think about these structural issues as you're going about identifying who is and who is not an insured organization under the policy.
And what DS is getting to there is that D&O policies have a definition of a subsidiary that will automatically include certain entities, separate legal entities, but that meet the terms of that definition, and it generally involves control and benefit and things like that. And so it may cover automatically your wholly owned taxable subsidiary, or if you're a trade association that has a kind of a controlled related foundation, it may automatically cover that. But as we've seen more times than I can count, there are many subsidiaries and affiliates like that, even taxable subs and related foundations, or a C3 that has a C4 affiliate, that don't fit that definition because of the governance structure or the lack of control or how the money flows between them. And so you really want to be careful where you do have separate legal entities that are part of the same family to explicitly make sure that those are all covered by your policy. If you're going to rely on that policy for coverage for all of those entities, then you absolutely need to be sure that's the case.
And yes.
Sorry, I don't know if you're going to bring it up later on, but since we're talking about insurance in a non-profit context, the question I have is if a claim is filed and paid upon, does on behalf of a director or officer in their personal debt for something to do with their official role with the organization, is there any kind of excess benefit or intermediate sanctions issue triggered? And does it make a difference if there's a deductible and the company pays the deductible on behalf of that director or officer?
Russell, it's an excellent question. It's a little bit off topic, though. If you follow up, I have a lot of experience with it. If you follow up with me offline, and I'll give you an answer to that.
Okay. I did want to, before we move off to the subject, just glom on just a little bit with what Jeff just said. Some D&O policies, if you happen to create a new subsidiary or you happen to create a new organization during the policy period, there are some policies under some circumstances which will immediately allow you to extend the coverage out to that entity. Sometimes they require notice. Sometimes there are the control provisions that Jeff alluded to. I just want to let you know that that's possible, at least whenever an organization asks me as to what it should do. I always say, tell the insurer and get it in writing. Because if you rely on that looking back, it's always difficult, and that extension of coverage, it's just a hornet's nest trying to thread that needle sometimes. So again, you need to put that as part of your due diligence if you're thinking of creating a new sub or taking on a sub and creating it as part of your taking it on as part of your organizational structure. Okay. Don't assume that your insurers know who your directors and officers are. Jeff alluded to this earlier, that directors and officers insurance isn't for directors and officers anymore. There are lots of people who could benefit from it. Trustees, those with dual responsibilities, shareholders, managers, even spouses under some D&O policies. The key is to identify everyone to whom you want to extend the coverage and be sure that they're covered by the policy that you purchase. What about other insured persons, like employees? Lots of times D&O coverage extends to employees. At least in our experience, the sticky issues arise with regard to volunteers, students earning credit, and interns. A very common definition that I've seen of volunteer is someone who donates her time without expectation of compensation. And under that scenario, I'm concerned about, for example, the trade association whose members allow their officers to serve in leadership roles on behalf of the trade association and who do so as part of their employment. Are they volunteers Well, they're volunteering their time to the organization, but they're not doing it for free. What about volunteers that expect compensation or reimbursement for travel expenses and certain expenses that are incurred on behalf of the organization? What about those interns looking for college credit? What about those interns who, like me, did work part-time in the hopes of getting a full-time position once he or she graduated from college or law school or any other graduate school? Those sorts of individuals, you just need to make sure that your definition of volunteers is sufficiently broad to capture those folks. Because for many nonprofit organizations, those folks can be the face of the organization, and they can be named as a defendant in any suit that's filed.
Two small points to highlight. Again, pay attention to the definition of which types of individuals are covered, specifically as it relates to compensation. As we know, while it's not the norm, there are a number of nonprofits that do compensate their board members for their board service. We have some clients that pay their board members upwards of $50,000, $75,000, $100,000 a year for their board service. That may trigger some sort of exclusion under the definitions in your D&O policy if you don't pay close attention to it. And secondly, it kind of goes without saying, employees are always covered by these policies, but someone who is really functioning like an employee but is being treated as an independent contractor by your organization for tax or benefit or other reasons, whether or not they're properly classified as an independent contractor is a different issue. But if you're going to be treating them as an independent contractor, you can almost guarantee that they're not going to be covered by your D&O policy.
The insurance company isn't exactly going to follow the IRS's lead, and the IRS isn't exactly going to follow the insurance company's lead. They'll take their own positions there. Okay. Don't assume that your insurers know what your insured persons expect. Depending on the type of policy that you've purchased, the insurance company will sometimes reimburse you after you've retained attorneys with whom you have a long-standing relationship, your preferred attorneys. Your in-house counsel or your general counsel has a relationship with the firm that he left before he came in, and you're going to use that firm to defend yourself. That's great if you have that type of long-standing relationship and you have that trust. Conflicts can still arise, however, because many times the insurance companies will impose a ceiling on fees, ceiling on hourly rates, that sort of thing that can kind of inhibit your ability to retain whomever you want. Lots of other times insurance companies take on the responsibility of responding on your behalf, the duty and responsibility to pay for counsel. So the insurance company is going to go out of its way to retain an attorney for you to defend the claim. That prevents you from having to scramble around trying to find somebody who can handle the claim, but it also gives you far less control over who's going to speak on behalf of the organization. And you may end up with someone you don't trust.
Yeah, the old adage, you get what you pay for, not to suggest that counsel who are on insurance companies' panels and are their kind of go-to counsel that get appointed in claims are not talented, qualified attorneys. But if you work with an attorney or a law firm that really knows your organization, has a great history with it, and really is going to be able to provide a level of service that's far superior to some attorney who's just brought in on the fly to help defend you in a particular case, there's going to be a big difference in the quality of the representation. One thing that DS and I have seen over the years is that even where the right to appoint counsel is very clear in the policy, which it generally is in these policies, pushback if there are circumstances that warrant why the insurance company should pay for your go-to counsel. We've been very successful over the years in many cases in convincing them to do so. Now, granted, oftentimes it's with an understanding that your go-to law firm is going to be only paid at the rate that the carrier would have paid the other firm, and then you have to decide whether you want to pay the difference to your firm or whether your firm's going to write off the difference. You can work those sorts of things out, but don't just make the assumption that you have to go with the attorney that the insurance carrier in the first instance decides they want to appoint.
Let me add a couple thoughts, too, about appointment of counsel by the carrier. That's under what's known as a duty to defend policy, where the carrier has the right, the duty to tender, to defend the matter and pay defense costs. It's a sweet deal for an insured organization to have a duty to defend provision because along with that, the responsibility to tender to the defense is the responsibility to pay for the defense and to pay for all the expenses, all the defense assertions against you, even those that are uncovered. So, while you may not have the right to select counsel, there is some balance in terms of what you're getting and what you're giving up. As Jeff and Dia said, there are circumstances where you may definitely want to petition the carrier to recognize your own counsel for the defense of whatever the claim may be. Let me help manage your expectations a little bit. If this is a garden variety employment practice, wrongful termination, don't bother, because the insurance company is going to say that doesn't require much expertise. I have quite a few qualified attorneys on our panel counsel roster, and we'd prefer to go that route. On the other hand, if you've got a matter that requires some awareness of your industry or your organization or the history of events that led to the litigation, by all means, you should at least petition the carrier to recognize outside counsel. Keep in mind that from their point of view, this is a transaction now. This is not about providing a defense that meets, whatever level of satisfaction you have. Their goal at this point, and it's not unreasonable, is that they're going to defend the matter so that it has a favorable economic outcome. You go to the carrier and you say, Venable can do this. They know us. They know the issues. They have the bench strength to do it. If it goes to trial, if it goes to appeal all over the country, the carrier is going to require that they agree to their litigation management guidelines, so they're not going to get whatever their normal retail rate is as part of defense. But that's a request that you should feel comfortable about making. Carrier can always say no. If you ever feel like the attorneys that have been assigned to you aren't up to the job, you don't trust them, you don't like them, whatever the reason is, go back and ask for another. That's not uncommon or unreasonable.
Right. And piggybacking on all of that is, at least looking on the back end, trying to negotiate these sorts of arrangements, it's probably better sometimes for your organization to kind of think about it on the front end, because we certainly can negotiate that sort of arrangement, but as Lou's identified, there are some garden variety cases where it's harder than when your trusted law firm has been there from step one and is fully entrenched in the issue and knows the legal issue, and it's a very specialized issue. That's when, oftentimes insurance companies are willing to bend on that sort of provision. Let's go to conflicts of interest. We're now talking about maverick directors. The director who was hired because he was the best guy out there, and suddenly it turned out that he doesn't exactly exercise great professional judgment, and now we need to get rid of him because he's been sued. These conflicts of interest can create very difficult circumstances that require the retention of different and separate counsel. Before all this goes down, as part of a corporate governance issue, you need to think about, as far as your D&O policy, as well as your bylaws, as well as the way you've structured your nonprofit organization, what are the circumstances that are going to result in our organization paying for or even advancing litigation fees, paying for judgments? What kind of protections are we going to provide to these types of individuals? Because on the front end, the maverick director may say, I won't work for your organization unless you provide me with this assurance. So these are things you need to work out on the front end and deal with on the back end.
And what DS is partially getting at there is that he referred earlier to the different sides of a D&O policy, A, B, and C. One of those sides relates to the insurance carrier providing coverage for cases where you are legally required to indemnify, say, your officers and directors for certain types of claims and expenses and defense costs, et cetera. That obligation to defend generally will be found in your Articles of Incorporation and or your bylaws of your organization, and sometimes will stem from the State Nonprofit Corporation Act of wherever your organization is incorporated. Generally, it's a combination of all of those things. We have seen some absolutely awful indemnification provisions in the past that go far beyond what state law requires, sometimes even beyond what state law permits, and you don't want to find yourself in a situation where you have an unreasonably and unnecessarily broad indemnification obligation, particularly, say, in a situation where you believe there was bad faith on the part of the director at issue, where the director, concealed a material conflict of interest that did significant harm to the organization. You may want to be able to be in a situation to try to deny indemnification and not have the insurance carrier be forced to step in and pay this claim, which you then have to deal with the consequences of later in terms of perhaps higher premiums and whatnot. So I think part of your overall review of your insurance coverage and trying to identify gaps and narrow those gaps and all the kinds of good stuff that DS does with nonprofits is also to look at your indemnification obligations in your own corporate documents and make sure they're appropriate and tailored for your needs, your risks, and are kind of line up with your state nonprofit corporation law.
Okay. This matching process between your organization and your needs for your D&O coverage also includes a consideration of what your organization does. Remember that D&O coverage only provides coverage for things that are done in the course of your business, or the things that are done in the course of an employee's employment, or things that are done in the course of volunteer activities. Many times insurers, as part of the application process, will ask your organization to describe what it does. My three rules are: be clear, be comprehensive, and don't be shy. The more transparent you are about what you do and accurately describing what it is your organization is going to do over the policy period, the better the insurance coverage provided. And as your organization evolves, also remember to keep your broker and your insurance company in the loop. Let's give an example. I think one nonprofit organization we've helped in the past helped with mortgage debt counseling, and that those efforts were genuine from the day the organization came off the ground. It told its D&O insurer that it was going to do mortgage debt counseling. It did everything it was expected to do as part of the application process, and lo and behold, in the middle of a policy period, it decided to branch out into credit counseling. Well, unfortunately, that organization didn't tell the insurer, who then, once sued, tried to submit that claim to the D&O insurer, who said, "What's this credit card counseling line of business you guys are in? We never priced the policy for that. We never thought about that type of risk when we issued the policy." It was a tough claim, and you can work through those things sometimes, but those are the things you need to keep in mind as you evolve your business. You also need to keep in mind where it is you do the work that you do. D&O policies often cover liabilities no matter where the underlying actions occur, anywhere in the world. But sometimes they limit where the claims are filed. So if you have something going on in Ghana and the policy requires that the claim be filed in the United States in order to be covered, that person's going to have to fly to Ghana to file the complaint against you in order to trigger the coverage. So if you're over in Ghana and you're going to be sued in Ghana, be sure to get yourself a D&O policy that's going to protect you in Ghana. So who should be involved in all of this matching? It sounds very simplistic, but you need to be involved in the matching. A lot of this depends on information from you and interaction with you. The stress needs to be on delegation, not abdication. So who are these people to whom you're going to delegate things? You're going to delegate things to your qualified insurance broker. Now, that individual is going to be responsible for understanding your organization and understanding your goals and going out and trying to find a good D&O policy to protect you as you pursue those goals. You should also discuss with your broker your claims history. Too many times we've seen nonprofit organizations experience a loss and then not take that into account when they renew the policy or purchase a new D&O policy. Lots of times this issue arises when nonprofit organizations are served with subpoenas. Believe it or not, there are D&O policies out there that will help you respond to congressional subpoenas and subpoenas issued by courts. You just have to purchase them. Many D&O policies don't provide that type of coverage. If you happen to have that coverage and you're served with a subpoena, I'm pretty sure the insurance company is not going to go out of its way to provide you with that coverage.
This is a really big area because so many nonprofits these days, even when the organization didn't even on the surface do anything wrong, often will get hit with a major investigative process. They'll get hit with a subpoena for documents and or information in connection with an investigation by a federal or state government agency, a congressional committee or whatnot, just because it's in the middle of an industry or a profession or an issue where it has a lot of information and knowledge, not necessarily alleging that the organization itself did anything wrong, but that it has information or knowledge that the investigator wants. Those investigations can be extremely costly to comply with and to deal with, and you often need outside counsel, and you're talking about huge amounts of staff time and potentially legal fees. This is one area where these D&O policies do vary greatly in terms of some covering these sorts of things, some not, and then even more specifically what types of investigations and subpoenas might be covered. So it's very important that you make sure that you have a policy and it's written in a way that gives you the broadest coverage necessary in this area.
Also, yes, sir.
Is there a rule of thumb in terms of the claims history? If we have a loss back in 1974, is that still going to show up on a loss roll? Is there a norm here for claim history?
And the question is there a norm here for claims history? Are you going to still be, are you still going to feel the effects of a claim that was filed back in the 70s and 2012? And unfortunately, sir, I'm going to have to give you the lawyer's answer. It depends. It depends on the insurer. It depends on the significance of the claim. If you got hit with a huge congressional investigation in the mid-70s, sometimes those things don't disappear. If it was a relatively minor claim, you may be able to find your way out of the woods. So it kind of depends on the insurer as well as the size of the claim.
Yes.
Yes, sir.
You're either going to be signing an application that's what's known as a main form, a new business application, which is going to ask as many questions about the background as the carrier wants to have, and that application should be pretty specific in terms of have you had any claims within the past X number of years, and you should expect it to be about 3 to 5 years, and obviously you need to disclose whatever would fall within the timing that they're asking for. A historical claim like that, a legacy claim, if it's out there, and you can't do anything about it. But there's no requirement. If the question doesn't get asked in an application, you don't need to say it. You only answer questions. Filling out an application, I've often said, it's like talking to your children about sex. Answer the question that gets asked. And if they ask for 3 years, give them 3 years. If they ask for 5, give them 5. But I wouldn't give them anything more than that. I probably shouldn't have said that.
Oh, it's fine. Sorry, we're going to have to hold questions in because we have about 20 minutes left, and we need to be sure we end roughly on time. So, Diaz, if you can try to wrap through the end of your discussion, we got to make sure we leave Lou a little bit of time here.
Okay, everyone, put on your seatbelts. We're going to go through the remainder. I'm going to try and get through the high points of the slides. I'll try and release a longer version that you could pay 25 cents a hit for if you'd like. After the presentation. So your broker is also going to be, you should also talk to your broker about claims filed against your competitors. It's the old, but for the grace of God, go I. And that's actually one of the things that we've helped nonprofits work through previously when their competitors have claims filed against them. Basically, is this policy going to protect me as well? Your broker needs to also work with you to frankly assess your potential liabilities, help you address them to the extent possible, and achieve an optimal level of coverage. This is a question that's asked often. How much D&O coverage should I buy? $5 million, $1 million, $10 million, $500,000? Your broker is going to be the best person to answer that question. All right. Believe it or not, the insurance carriers are also very good resources insofar as they have particular strengths. And, to the extent that you can figure out what they're covering, that's what you should really think about obtaining. Coverage counsel can also, for many of the reasons that Jeff has been describing, insurance coverage counsel can also help you make that determination. Now, your D&O needs are not set in stone. Again, think about as your organization evolves, as your people evolve, as everything moves forward, keep going back and thinking about what are my risks. Is my D&O policy sufficient to cover those new risks? Am I accounting for what's already happened in the past as well? You also need to keep a close eye on your policy periods to make sure that 30, 60, even 90 days before your D&O policy elapses, you've given the serious thought about where you want to go in the future and to make sure your D&O coverage follows you there. One thing that I want everyone to kind of pull away from this presentation at least is simply because you've purchased a renewed policy, that does not mean that it's the same policy that you had last year. In this renewal process, we've seen new endorsements, new exclusions, new limitations come through as part of the renewal process. Now, what should you do in order to make sure that you satisfy your obligations to your directors and officers? First of all, insurance is part of the risk management program, not the risk management program. The best policy is one that you never need. So how can you do that? Identify and address risks that you can or should eliminate. If that credit card counseling portion of your business isn't making money and is resulting in a lot of claims, get rid of it and get back to helping people work through their mortgages. You can identify and address risks that you can and or should limit. Again, lunch and learns are a great way to do this, as well as to raise awareness about your risks to ensure that things don't happen again and again. These are also great reasons to have lunch with your broker or your insurance coverage counsel just to figure out what's out there to make sure that you're protected. What can you do with the inside of your D&O policy? Well, number one, read it. It's a really short policy, and it's probably worth reading more than 15 minutes after you've been filed with a complaint. So take a look at it. If you don't understand it, call somebody about it. Ask your broker, ask your insurance coverage counsel, ask someone to understand it. Keep it. If you have a claim come through the door, you don't want to be scrambling around trying to find your policy. It sounds outrageous, but I've waited more than a week for some very sophisticated nonprofit organizations to give me their policies so that I can help them move forward. Those policies need to be kept very handy and safe. Oh. All right. Let's talk about some of the limitations that can creep into your policies. You've heard about exclusions, and they explicitly preclude coverage for losses arising from certain conduct, activities, or circumstances. Now, for those in the nonprofit world, the important ones tend to be the intentional acts exclusion, the dishonest acts exclusion, the acts for personal gain exclusion, and various antitrust exclusions. This reaffirms the point why not every nonprofit organization should have the same D&O policy. These are actual examples from our practice. We've seen an insurance company try to sell a D&O policy with an exclusion prohibiting coverage for all lobbying activity. The problem was the client was a lobbying organization. We've seen a standard-setting exclusion. That is, you don't get coverage for any standards that you set on behalf of other organizations. We've seen that exclusion, we've seen policies including that exclusion peddled to a trade organization. That, among other things, set best standards for the industry. We've seen that same exclusion appear in a policy that was offered to an accreditation organization. The point is, not every exclusion affects every organization the same. So how do you protect yourself? I call these safe harbors. That is, you carve out certain parts of the exclusion to protect yourself. I think this is best shown with some examples. The dishonesty exclusion. The exclusion prohibits coverage for dishonest, fraudulent, or criminal acts or exclusions. No insurance company is going to provide you with coverage for that type of activity. But if you're sued and the allegations raise those sorts of allegations, but also include claims of negligence, you may be able to secure a defense if you have a carve-out, like the one that's underlined, basically saying if the insurer's duty to defend would have been triggered but for those allegations, you have a defense until there's a judgment or an admission. So until a judge, jury, or you admit that you committed fraudulent acts, you've got a defense. Another example, intentional acts exclusion. Policy excludes coverage for loss arising from acts expected or intended to cause property damage or bodily harm. Lots of policies stop, period, there. We've seen some that said, except that this exclusion does not pertain to any wrongful acts as defined by the policy. You have an exclusion, then you carve out a safe harbor to protect yourself and your organization. And finally, conditions. Now, these conditions are basically the insurance company's way of saying, we will provide you with coverage so long as, and it's so long as where people get in trouble. Two most important ones from my perspective at least, duty to report potentially covered events promptly or within a certain number of days. That is, if you get the complaint in and the policy says get it in within 15 days, do everything you can to get it in within 15 days. Now, if you blow that 15-day period, there are certain states that will require the insurance company to show prejudice. That is, if you submitted it on day 16 and it made not a difference in the world, they're not going to be able to avoid their coverage. But if you did it 15 years later and lots has changed and the claim is now basically you've got no defense, at that point you're going to have problems getting coverage. Finally, duty to cooperate. Sometimes the requests are onerous. Sometimes the requests require a lot of time and a lot of documents, but do your best to cooperate. Otherwise, the insurance company is going to try and find a way to take away your coverage. Thank you.
Thanks, Diaz. And with our approximately 15 minutes remaining, turn it over to Lou Novick to complete our discussion today. We may end up going a few minutes over, and then, of course, for those of you in the room, we'll stick around afterward for questions.
We'll turn this into the lightning round here. There's been a fair amount of discussion about a director's and officer's liability and who it covers and what it covers. So the first few slides that we're going to talk about are just that. Who's covered under a D&O policy and what are you covered for? And we could spend from now through supper talking about any one of these. I'm going to go very quickly, and if you have any questions, we could probably talk about them afterward. But a director's and officers, a nonprofit director's and officers liability policy is distinct from a for-profit D&O policy. Pretty broad roster of insureds. It's directors, it's officers, it's employees, it's volunteers, it's committee members. Very significantly, I don't have up there, it's the entity itself as a named insured. And that's one of the things that makes it distinctive in most respects from the D&O policy that your members, your board members may be more familiar with. If they're coming from the for-profit world, they think of a D&O policy as a director's and officer's liability policy where there may not be entity coverage. The key here, the real over-under, is that in order to be entitled to coverage, whether you're a director, an officer, a committee member, volunteer, whatever, you have to be acting within the scope of your authority. If you don't have the authority to act or you're acting outside your capacity, then you're not entitled to coverage. So that issue of was it an insured capacity or was it something other than an insured capacity is real significant. And how do you determine where capacity is established? It's a bylaw issue. If the authority to act on behalf of the organization isn't there in the bylaws because you're on the nominating committee, you're a director, you're an officer, you don't have that. Where you seek to create authority for someone to work, have a resolution to the meeting minutes that says, we're paneling we're forming a new committee or something like that, and that's enough to get people in. Very significantly, who's not insured? Who's not an insured under this policy? And Diaz was talking a little bit about it. Jeff was talking a little bit about it. Very often we'll see in bylaws that the indemnification provision extends to agents. And Jeff, I'd defer to you, Diaz. I think that sort of comes out of sort of Delaware corporate law where that's a fairly important capacity within a for-profit organization. But in a non-profit organization, first of all, it's not a defined term. I don't know what an agent is. And second of all, it's not covered under your insurance policy. If they're not a director, an officer, a volunteer, they're not covered. So an agent, though that capacity may be entitled to indemnification pursuant to your bylaws, that's not an obligation that the insurance company is going to undertake. So be careful about that.
Yeah, and that's another place to really scrutinize your indemnification clauses. Certainly officers, directors, and employees are agents of your organization. Those are types of agents. What Lou's talking about is agents who are not officers, directors, employees, committee members, volunteers. And just like your D&O policy is not going to provide coverage for claims that arise from their activities. Similarly, you don't want your indemnification obligation to extend to those folks.
So we talked about the who is covered. Now we're going to talk about the what is covered. And what you see up on the screen now are what are known as perils. And perils are things that can cause a claim. The single biggest source of nonprofit director and officer liability claim activity, number one with a bullet, is employment practice liability. 9 out of 10 claims that perk up under this policy are going to be some variant of a wrongful termination. Failure to hire, failure to promote, wrongful deprivation of this, harassment, discrimination. 90% of reported claims, nonprofit D&O, right there, employment practice. They tend to be very high frequency events, but they tend to be fairly low severity events. Personal injury, libel, slander, defamation is probably, in terms of frequency, the next most frequent source of claims. It's characterized by low frequency and relatively low severity.
Although happening a bit more and more these days because of the use of social media by nonprofits and nonprofit officers, directors, and employees.
Publisher's liability, and what I mean when I say publisher's liability, I mean the administrative perils of publishing. So it's plagiarism and invasion of privacy and unauthorized use of likeness, things like that. You should expect to find those fairly well established among the insured perils in your nonprofit D&O policy. Again, fairly low frequency, fairly low severity. The plagiarism, the content that is plagiarized, if it doesn't have a lot of money value on it, then the demand for damages because of the unauthorized use is not going to have a lot of money on it either. Where the cost begins to rise has to do with certain professional service perils, accreditation, standard setting, antitrust. You would expect under most nonprofit D&O policies to see one of two things. Either you're going to find a professional services exclusion that says we don't cover any of that. We don't cover accreditation or standard setting or certification. Or you're going to find what DS was calling a carve-back provision, where the carrier says, and this will be by endorsement, it says, these are excluded except up to $1 million for this, or up to $500,000, or up to $500,000 of defense costs associated with the standard setting or the accreditation. So that it's going to be one of the other. But don't forget, the bedrock exclusion under this nonprofit D&O policy, anybody remember? BI and PD. So if your standard setting results in a bodily injury or property damage claim, it won't matter that you've got a sublimit. That claim's going to be denied. Breach of contract, DS, I don't remember if it was DS or Jeff, but it's against public policy. Insurance companies don't want to insure breach of contract. If they did, it would effectively introduce a moral hazard. If you knew you could get out from under a bad deal, you'd sign the deal, you'd work it until it was no longer satisfactory, then you'd breach the contract because you knew you could transfer that to the carrier. Can't do that. Most nonprofit D&O policies will include coverage for the defense portion of breach of contract, but only the defense portion of breach of contract, and some of them won't cover that.
And of course, there is one exception to that. The one type of contract that often can be covered by certain D&O policies is employment contracts, particularly for the chief executive.
Antitrust is the mother of all D&O claims. If you're a C6, you have an exposure to antitrust, almost by definition. The axiom in our business, I guess, is if you don't need it, we'll give you lots of it at a good price, and if we think you need it, you either can't have it or you can't afford it. It's not entirely that way, but you should be mindful. If antitrust is a peril that you recognize within your organization, the only place you're going to find coverage, well, I shouldn't say the only place, but the principal place you're going to find coverage is going to be in your nonprofit D&O policy. If you have an E&O policy, you might find some basic coverage there as well. It will not, if you've got $5 million or $2 million or $3 million of limits, you're not going to get that limit of liability for the antitrust. You'll be offered, at best, what's known as a sublimit, some fraction of what the policy aggregate limit is. If your policy says nothing about antitrust. It doesn't say you haven't. It doesn't say it's excluded. That's known as silence. And it's either a good thing or a not good thing. I generally believe if you have if within the scope of your operations, you've got an activity that leads to a significant threat of liability damage, relying on policy silence is not a good thing. You'll want to see something in the policy that says affirmatively you've got the coverage, you've got this much coverage, or you don't have any coverage at all. I don't think you can rely on policy silence, particularly with antitrust.
Yeah, Lou and I have discussed that in the past, and I generally agree with that. Of course, you always run the risk that if you raise something like that, the carrier is going to come back and just slap an express exclusion on there, or say you're going to have to pay extra if you want to get that. Anyway, just something to keep in mind.
And, of course, the biggest value of directors and officers' liability, or any liability for that matter, to most insured organizations is going to be defense. Most claims open and close without any payment to a plaintiff, but defense costs above a retention are almost always incurred. So the real value to most of the organizations here today and listening today is the defense costs.
And I should just clarify one thing. The reason that Lou is saying you may or may not have coverage, say, if it's silent, is that sometimes these policies will spell out specific types of claims that are covered, like employment claims, copyright and trademark infringement, defamation, invasion of privacy. But then you have that general definition of a wrongful act. And that's what, in that situation, you would be relying on that general definition, essentially, of negligence in hoping to cover it. But sometimes, and we've seen this happen, the carrier will come back when a claim is filed and say, sorry, we interpret it differently and there's no coverage.
Or in the case of an antitrust claim, the policy's silent. You won't find the words, you won't find Sherman or Clayton or anything like that in there. And you'll go, well, it's not excluded, so it must be covered. The carrier doesn't need, even though the carrier may have an endorsement that they use when they really want to exclude antitrust, there's still other restrictive provisions in the policy that they can point to. And the most useful one to the carrier in asserting a policy defense is going to be the intentional wrongful act. You knew, you did it, you knew you did it, you intended to do it, and even though we're not going to exclude it because we don't have an antitrust exclusion, we're going to exclude it on the basis of intentional act. I find it very humorous sometimes when I read listservs and the traffic will go back and forth and say, well, how much D&O do you have? And somebody say, well, I have 1 million. And somebody else will write and say, well, we have 2 million. And you can just picture some of these people at their keyboard going, I got 5 million, And I'm very unimpressed, as a risk manager, I'm very unimpressed at how much insurance you have. I'm more interested in is the quality of the terms and conditions of coverage. And I think that ought to be your first order of concern, is not how much do you have, but do the terms and conditions match up well in the way that DS was talking about assessing your risks.
Lou, if I could just interject for a second. This is actually, that slide about 1 million meaning more than 2 million is pretty much a crystallization of a question that I've probably fielded about 100 times, which is, okay, I understand that I've got a really bad D&O policy. I'll just buy a bigger policy. Well, no, you don't have a better policy. You just have more of a junk policy. So you got to kind of step back and look at the exclusions and things, because 1 million really can be more than 2 million. It just depends on how much is carved out.
Look, the most important provision in your policy is the one that touches on your claim, so I can't stand here today and tell you which one you should go back to the office and read. But if I had to pick a few, these would be on my top 5 list, and I want to add one other as well. We've already talked about defense, and so I think we're just piling on if we say more. Severability is important. Severability is the concept that because of a certain event, one or more people or the entity itself may be severed from coverage. And if you're not familiar with that, go back to your policies, go back to your application, and what you'll find in the policy is going to be a provision known as representations and severability, and it says if you misrepresent something and you're an individual, that may sever coverage for you, but it probably won't affect anybody else. It might, because you misrepresented or you withheld knowledge, restrict coverage against for the entity. So that's what severability is. Severability can also be found at exclusions. So you committed fraud, and as a result of that, the policy exclusion is triggered, but I didn't do it. I didn't know anything about it. I may be impacted by your fraud, or depending upon how this particular provision reads, I may be excused from that fraud. So it's a longer conversation than we could go into today, even if we had much more time, but it's not one that you should overlook. And the takeaway for this is the more generous terms of coverage are going to be that the entity is not severed from coverage, that a wrongful act or misrepresentation only severs the individual who either knew it or did it, and doesn't sever coverage for the other named insureds. Cancellation, I think DS talked about it. You want a policy whose cancellation provision is premium payment only. You do not want a carrier reserving to itself the right to midterm cancel. There's lots of circumstances where it could happen. It doesn't happen often, but given a choice between the two, you only want cancellation for non-payment of premium. Fraud, talked about that. I don't think I'll talk about that anymore. Coverage territory, be mindful of it. Anybody with a website is basically doing business overseas now. The coverage territory provision, for those of you who feel the need to go back and research this when you get to the office, that's going to be the header, the paragraph header. And it'll basically say you have true worldwide coverage. Bad thing could happen anywhere. Demand for damages can take place anywhere in the world. Or the alternative will be limited worldwide. Bad thing can happen anywhere, but the demand for damages has to take place in the defined coverage territory, which is going to be usually U.S., Canada. Again, if you have overseas operations, you're going to want to be sensitive to that true worldwide coverage. The one thing that we didn't talk about, and it's not up on the slide, is notice. That's another provision. Actually, Jeff, I think you raised it. It's the requirement that you tell the carrier, or yes, you might have said, I've forgotten by now, but it's a requirement that you tell the carrier of knowledge of circumstances that have either resulted in a claim or may not have resulted in a claim, but may reasonably be expected to lead to a claim. Different policies are going to have different notice requirements, but the policy requirement, the contractual requirement, is a condition precedent. Notice is a condition precedent to any rights that you have under the policy. So it means if you don't do this, you don't have the right to tell the carrier to perform their obligations to you. Notice is important. Forget the fact that don't confuse your personal insurance experience with this. If you've got a claim or knowledge of circumstances that might lead to a claim, my experience has been you're better off putting the carrier on notice right away. Last thing I'll tell you today, well, the question is, can we get it for less? You can always, we can always sell you a policy for less, but it's important that whoever the agent or broker is that you're dealing with feels comfortable with the carrier relationship as well. There are certain carriers that we know well. They're not going to be the least expensive carriers in the business, but we have enough of a relationship and history with them that if I need to go back at the time of a claim and speak to somebody's going to answer my telephone call. That may not always be true if I'm shopping the low-price market all the time. One or two takeaways. Not everybody realizes that a lot of claims, well, of course, a lot of claims get denied on the basis of exclusions in the policy, but a lot of claims get denied on the basis of applications. And misrepresentations, even though they may be innocent misrepresentations in an application, can haunt you. The takeaway here is if you're new in the job, if you've just come onto your organization or you've just succeeded to that particular position where you're responsible for insurance, you're pretty well served to go back and look at the representations that your predecessors have made. Anything you find that doesn't line up with your understanding of the truth may rise to a level that you should be telling the carrier, I need to amend my disclosures. Because if you don't, the application that was signed 2 or 3 or 5 years ago is just as binding on today's policy as the one that you signed for this renewal. So that's certainly worthwhile for those of you who may be new to it. One other thing I'll say, DS was talking about the merit, and I absolutely believe this is true, of your becoming familiar with policy terms and conditions. I think where you and I differ is I don't have any expectation of you sitting down, reading your policy front to back, getting an understanding of it. That's my job. That's his job. My expectation of you, I think you folks in the room listening can be great risk managers, really great advocates for your organization if you have enough awareness around what your objectives, what your risk management objectives are, and then work with folks like Venable and us to make certain that those objectives are met in the policy. But your awareness of the policy terms and conditions, in my experience, most association executives just don't devote themselves or can devote themselves to that. So I think if you set realistic expectations, you can be a really good advocate for your organization. That's it.
Thank you, Lou. Thank you, DS, for a great presentation. Thanks for all of you for joining us here today, and we hope to see you back here next month. Have a good afternoon.
Thank you. Please stand by.